Hey guys, this is Raymond De Leon with Smoothoperationoflaw. I just wanted to make a video about the redemption movement. All right, now I'm making this video not to shit on people, but I need to show you guys why it's so critical that you are aware of how to actually operate law. And when I mean you guys, I'm just, like I tell you guys all the time, I'm just reporting. This is the First Amendment. You know what I mean? This isn't legal advice, but this is why people need competency. All right. So the redemption movement. The redemption movement is a debt resistance movement and fraud scheme active primarily in the United States and Canada. Participants allege that a secret fund is created for every citizen at birth, and the procedure exists to redeem or reclaim this fund to pay bills. Common redemption schemes include A4V, Treasury Direct Accounts, and Secured Party Creditor kits. Although the movement has maintained a following since the 1990s, its theories are false and meritless. Those who participate in redemption schemes, and especially those who promote them to other people, can face criminal charges and imprisonment. Several government institutions have issued warnings about the fraudulent character of redemption schemes. So the ideas of the redemption movement should not be confused with actual legal rights of redemption, under which a debtor may buy back property that has been levied or foreclosed, either by paying the balance of the debt or by matching the price at which the property sells. Now, I'm not going to go into all of the, the little things back and forth, all that crap, okay? But what I will tell you is that key points will be, by the late 1990s, the belief in a secret bank account had become a fixture of the redemption schemes. The origin of this idea is not clear, but elements appear in Lodi v. Lodi. In that case, plaintiff Oreste Lodi sued Oreste Lodi beneficiary, produced the birth certificate as evidence that the defendant controlled his estate, and served his complaint upon the IRS. The Shasta County Superior Court dismissed the plaintiff Lodi's case for the failure to state a claim. All right, and then these are purported redemption methods, okay? They rest on the same assumptions. 1, a distinction between a living individual and a corresponding legal person or straw man. 2, valuable property associated with the legal person, but rightfully belonging to the individual. And 3, a supposed procedure by which the individual can claim the property to pay debts. Promoters justify these assumptions with elaborate historical tales. Remember that, historical tales. The most common explanation of the claims is that the United States went bankrupt when it abandoned the gold standard in 1933 and started using its citizens as collateral so that it could borrow money. Supposed procedures for using the non-existent straw man funds include UCC 1 or UCC 3 against the straw man, passing a birth certificate or other official documents as if they were a bond. Okay, submitting documents to the Secretary of the Treasury asserting copyright or name. You cannot copyright a name. You can only trademark a name. And then all this other stuff with Social Security and the Treasury Direct Accounts and all that stuff. Returning bills, collection letters, and court notices with acceptance for value, the 1099 OID, corresponding with red ink, and all those type of things. Now, I'm going to make a long story short because I wanted to highlight these things and make only a 15-minute video and give you 10 minutes of my explanation as to why the redemption movement sucks at life. The reason why is because they don't give you, as it said in the beginning, it doesn't give you the actual legal right of redemption. Let me explain to you what redemption is. Redemption means to redeem. We all know what redeem means. It means to bring in some sort of certificate or document or claim a right, and then to get the property that belongs to you the right way. You need to be authorized. There must be some sort of authority. Now, here's the deal. Whoops. Matter of fact, let me see. Okay, here we go. Give me 1 second, guys. Now, when I say that you should be able to redeem for a claim, okay, I keep bringing this law up, 15 U.S.C. Section 1122. What is it? It's the trademark law for waiver of sovereign immunity from the state. There is an actual law. You guys can see it. It's on Cornell University. You can get your trademark back and attack all financial transactions associated with that mark because it's preclusory. It precludes people from using it. That is a legal right of redemption. There is a law. There is a claim that you can make in which relief can be granted. So a lot of these UCC ones and things like that, they don't mean nothing. They don't mean a goddamn thing. All I want to let you guys know is that by utilizing the trademark process, actually creating a trust, actually being able to know how to operate a trust with that intellectual property inside of it, actually being able to make a security agreement that is valid, okay? This is the Model Intellectual Property Security Agreement, okay, for the United States. So a lot of lawyers are going to use this, and it's going to get into, if you see, trademark intent to use applications. It's going to get into your actual trademarks. Now, you can have copyrights, but you can't copyright a name. If you want the reference and source to that, just put in a Google search and just check out, can I copyright my name? And you're going to find out you can't. So there is no such thing as a common law copyright. All the other internal documents with a lot of these redemption movements, they can be valid, but they're only between you and a debtor, and they're trying to use your Social Security as a debtor. You cannot sue the state for contract interference, be advised. But what you can sue them for is grabbing somebody's intellectual property because intellectual property is considered property. So it becomes a Fifth Amendment takings clause violation. If you want a case for that, just check out Seminole Tribe's case, okay? So, bottom line, or Allen v. Cooper, in which, as I said, you need 2 prongs. Those 2 prongs are willfulness and not enough adequate state remedy to get that property back. So, is there a redemption movement? Well, there's a legal right of redemption. There is not a secured party creditor process that is valid. The birth bond does not hold $100 million. And if so, and you can prove that, I dare you to put it in the comment section. You can't. Not unless it's some other mouthpiece just running their face. Okay? If Title 15, Section 1122, 1125, 1117, 1114, all those, freaking Lanham Act statutes are all scribed in and they are in effect. And the only way that you can waive sovereign immunity of a state is if you have a Supreme Court case that contextualizes the application of that law, because it allows for the Supreme Court to dictate how that law will be applied. Sometimes you can read a statute and that statute might not apply to a state entity because they have qualified immunity. It must say expressed in the statute that there is a waiver of sovereign immunity and that you have the consent of the United States in order to sue them, or consent of the states, and that the federal government will enforce. Or at least in your state, there must be a clear express statute that gives some sort of limited waiver of sovereign immunity. They will entertain claims up to a certain amount, but it will be expressed in the statute when it's legislated that there is a waiver of sovereign immunity and that there is a quantifiable legal right of claim if you prove the facts. So that's what I wanted to get across to you guys today. Okay? That's why I give OJT, on-the-job training, on how to handle intellectual property rights. Because if you can handle intellectual property rights, you can kind of put it in your head how far you'll be able to go. Okay? Do not ever confuse any of these videos with any of those other groups that are out there. That's why, you don't see any of that stuff on my videos. There is no historical background or legal theory that I'm trying to implement whenever I'm talking and making these vlogs. You've been notified. The redemption movement does not work, and it is also acknowledged as citizens being malfeasant. There is no gain from it. There is no win from it. I get a lot of people that sit down in the comment sections everywhere and about, and I'll see comments that come across that people are like, oh, there are no laws. There is no this. There is no that. Well, if there are no laws, then why is it that laws are being enforced? Oh, because it's a fraud. It's a thing. Okay, well, then make yourself a better negotiator because that's the situation you're in. All this spiritual stuff, it's all good. But that's not society's position. Society has a social compact. My job that I've undertaken for myself and growth is to be able to understand these topics, make a vlog, almost like a memoir to myself, but it's reporting, like a news reporter. And so you've gotten the news, okay? I want y'all to have a good afternoon, and if you guys got any questions on the proper way to protect your trademark and to actually get the desired result that the redemption movement claims. It's not done by the redemption movement. It is done by trademark. The entire end game that comes from the redemption movement, what you know it to equal, take that redemption movement and exchange it with the trademark process, and you will get that desired result. Period. This ain't legal advice. Go ahead and find yourself a competent attorney before you try anything. Blah, 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 blah. Good afternoon. All right. Come on. And we're stopping.